Cause y'all know what it is.
Network.
I was with Rich Rapper.
I fucks with you.
Warning, this video is for satire, educational, and comedy use only. It is not intended to be actual fact, nor is it intended to give real meaning to any of the questions you ponder about later.
We go. Defendant Eugene Henley Jr. Big U just got a win, and I don't know if the internet gonna like that one. So here we go. Defendant Eugene Henley Jr.'s ex parte application to set briefing and hearing schedule for reassigned wiretap suppression motions. Declaration of Craig A. Harbaugh. Must be one of the Harbaugh,
Okay, wait, Loco, are you in jail? Are you incarcerated?
Coaches.
Loco, I'm gonna talk to you in the chat, so I gotta talk over the video.
I'm joking. This ain't no joking matter, though. Let's get to it. Introduction. Defendant Eugene Henley Jr. respectfully applies ex parte for an order setting a status conference on July 9, 2026, the first date both parties are available, and from that, conference setting a briefing and hearing schedule for the wiretap suppression motions reassigned to this court, docket numbers 174, 189, 194, 195, and 258. A status conference is the necessary first step. The recusal and reassignment have left both the schedule and the structure of the evidentiary hearing for this court to set. The July 15, 2026 hearing, the recused judge set will not go forward, and the July 3rd, 2026 supplemental briefing deadline was key to that hearing. The order that set them expressly permitted modification, docket number 342 at 2. A brief conference lets the court reset the schedule and define the hearing it will conduct in one step. Mr. Henley proposes that the court set the status conference for July 9, 2026, a supplemental briefing deadline of August 6, 2026, and a hearing on September 24, 2026, or October 8, 2026. Subject to the court's direction at the conference, the government takes no position on the briefing and hearing dates and defers to the court and does not believe a status conference is necessary. Wait, what you mean? You don't mean, wait, Jay, you talking about briefing on the old schedule before this court? Hold on.
Man, Seti Nash giving us updates with this Big U case. Now, if he gets some things going his way and he ends up back on the streets, it's going to be crazy for some of you niggas.
There is no longer any reason to hold the parties to the July 3rd, 2026 deadline. Briefing on the old schedule before this court has identified what it needs to decide these motions. Risk supplemental briefs that do not reach the court's concerns, and a further round the court would have to order. Setting a conference first lets the court define the briefing and the shape of the evidentiary hearing and the outset and receive one set of submissions built to answer its questions. So this ain't really about nothing. It's really about just setting it all up to have all the evidence you want to hear, the wiretaps and all that shit. And we'll get into that at the very end because there's something being said on the internet that I 1,000,000% disagree because of the phrase, if the shoe was on the other foot. But basically, we got to set this schedule up. We got to get all this shit straight before we even proceed. Let's make sure we got all this stuff set up. And the reason why is pretty interesting. On May 18, 2026, Judge Allen.
Outside of the court of public opinion, it doesn't seem like they really have anything on Big U outside of public opinion. You feel me?
Rocha set a hearing schedule for all pretrial motions. Set the wiretap suppression motions for hearing on July 15, 2026, and set an evidentiary/Frank's hearing on Mr. Henley's motion to suppress intercepted communications for the same date, docket number 342 at 2. The order provided that the dates in this order may be modified as needed. Following the June 10, 2026 hearing, the court set July 3rd, 2026 as the deadline for any supplemental briefing on the wiretap motions in advance of the July 15, 2026 hearing, docket number 358. On June 22nd, 2026, Judge Rocha recused himself from the wiretap suppression motions. Wait, what? The court explained that because it had reviewed, considered, and authorized the pre-indictment wiretaps that are subject of the pending motions to suppress, it recused out of an abundance of caution, finding that a reasonable person with knowledge of all the facts would conclude that this court's impartiality might reasonably be questioned under 455A. The court denied Mr. Henley's pending request to reassign the motions.
Check the laundry.
Nah, bro, you gotta let it happen. What the fuck is you talking about? Also,
it definitely seems like what he has going on doesn't seem like the DA or the government really has too much on him. It seems like Big U was being made an example out of, and again, outside of courts of public opinion, it doesn't really seem like they have anything on this man outside of that PPP stuff. You feel me?
so on June 22nd, 2026, the wiretap suppression motions.
Yeah, it seemed like it's a lot of overt acts. But with the exception of the one against Whack, the overt acts can't really be tried towards anything. The situation with Whack can be tried for something because Whack told that story about how they were at the club and that situation happened at the game concert, and Whack went on No Jumper and told that whole story. So now the government has an eyewitness, and then you have people on the videos and all that kind of stuff. So it's a lot of things that went into that put that case on him. But outside of that, it's not really anything.
Enjoinders, docket numbers, we ain't doing all that, were referred to a randomly drawn district judge and assigned to this court docket 359.
See, here's the thing about this. Loco, I believe like this. The rules only work if everybody's following them. I'm a defensive player. You make the rules, I'll play the game. The standard rules only work if we're all playing a standard game. But a standard game is not being played, so I'm not going to play by standard rules. I think that it's stupid every time somebody goes on the internet and say, oh, man, well, it's the internet. I can't do this. I can't do that. Whack and Flacco do whatever they want to do on the internet. They do whatever they want to do, how they want to do, when they want to do, and that's how they acquire their wins. So you mean to tell me that I'm going to take a loss because I don't want to adjust the way that my game is being played? Oh no, that's unacceptable. I'm not going to take a loss to a buster, to a flu flammer, to a skulldugger, and make the excuse of, oh well, no, I just don't do that on the internet and blah blah. No, hell no. You're not going to pick on me, play with me, disrespect me, and I ain't finna get my get back. However, I got to get my get back. And what I will never do is allow myself to be bullied, to be harassed, and to be flu, flam, skull, dug, and Larson to the point where I say, oh, well, man, I'm going to just let them have it. I'm gonna just leave them alone. They're going to have it. I'm going to just leave them alone, blah, blah, blah. After we done went this far? We done went this far? And all of a sudden, I'm going to just let y'all have it? No.
Docket 361, directing
to the point of Big U, it seems like the only thing they have him on is the taxes and he can't really explain what happened to that money.
Clerk to reassign the motions to another district judge. On June 27, 2026, defense counsel proposed a schedule set out above to the government. Harbaugh declared on June 29, 2026, the government responded that it takes no position on the briefing and hearing dates and will defer to the court, and that it does not believe a status conference necessary. The government also advised that it is likely not available on July 2nd, 2026, but is available on July 9th. So as we said before, and people went, the freaking comment section was split in half. We said the old judge had to go as far as the wiretaps go because he couldn't be unbiased. He approved the damn wiretaps. So you're not going to go back and then say, oh, I made a mistake. You're not going to do that. Nobody would reasonably say, hey, man, that judge was completely unbiased. So they're doing this shit by the book. Thank you, feds, for finally doing something right. Thank you, feds, for doing something right, because you can't look at the shit you did and then go, oh, I got this wrong, and think that if you don't point out something you got wrong, that we ain't going to look at you and go, yeah, bro, nah, hold the hell on. Nah, something ain't right. Go get somebody else, because you can't be the person to fix your own mistakes.
Can't be the person to fix your own mistakes. That's not true. That's real. And then I'll also say this. Should Big U get off on this, considering the fact that he's still in jail waiting on time? I don't know how the feds work, but I know that in the LA County jail, you do get good time while fighting your case. Let me see exactly how this works as far as the feds are concerned. Let me see something real quick. Let's pull up Trap GPT for a quick second. Trap GPT, are you there?
Right here. What's up?
Are you aware that in the Los Angeles County Jail, they get 2 for 1 days, meaning if you serve a month while fighting your case, you'll be credited for 2 months?
Let me double check on that. So, yes, that is a thing. but it is complicated. California does award pre-sentence custody credits, often called half-time or 2-for-1, but it is not automatic for everyone. It is going to depend on the specific charges. And
well, I just want to talk about this in a very general statement. Does that apply for the feds too? If somebody's locked up in the Los Angeles downtown federal detention center, would that the same thing be applicable?
Checking. Okay, generally, no. In the federal system, in a place like MBC, Los Angeles, pre-trial custody is typically just day-for-day credit towards your sentence, not 2-for-1. After sentencing, there are separate programs that might reduce time, but not through blanket 2-for-1 rule.
All right, so now we know. Let's keep going.
That's why we have appeals and all of this shit. And judges getting booted off from hearing their own damn shit. So shout out to Big U's lawyers for catching that shit. We agreed, by the way, and that shit was split down the middle. People thought Big U was paying me, and I'm like, I'm just being fair as I possibly can. But let's continue on with this third part argument. A status.
So many people having a distaste for Big U that you think that Sadie Nash is being paid when he's just making YouTube videos. That is incredible. That is incredible.
Conference on July 9, 2026 is the necessary first step. A status conference is the efficient way to reset these motions. And July 9, 2026 is the first date the parties can hold one. The court is entering the case after a year of litigation. Accordingly, it is important that the court has an opportunity to set its own schedule in the parameters of the evidentiary hearing it will conduct. A status conference lets the court do both at once. It also avoids the alternative supplemental briefs filed on the old schedule that may not reach what this court needs to resolve the motions, leaving the court to order a further round. The parties have conferred. The government advised that it likely could not proceed on July 2nd, 2026, but is available on July 9th, 2026. And July 9th is the first date both sides can appear. The conference should set the...
Yeah, it seems like the only thing that they really got, again, like I hear all the words, I hear all the rumors, but it's like you said, like that's not enough to convict an innocent man. It seems like he's not guilty of anything outside of getting on y'all nerves.
Briefing schedule and the structure of the evidentiary hearing. The prior schedule did not contemplate argument alone. It set an evidentiary/Franks hearing on Mr. Henley's motion to suppress intercepted communications. A live evidentiary hearing turns on questions the court will want to settle. That's what we'll want to. I can't read for shit right now.
Okay, words are hard.
Want settled before briefing, which witnesses will be called, the order and time estimate for their testimony, and whether the parties should exchange witness declarations in advance to narrow the issues and shorten the testimony the court must hear. Defining these at a conference lets the court receive supplemental briefing and any supporting declarations built to its own procedure. Avoiding the need for further briefing, the existing dates do not stand in the way. The July 3rd, 2026 supplemental briefing date and July 15, 2026 hearing were tied to a schedule set by the recused judge, and the scheduling order expressly contemplated modification. With the July 15 hearing on the July 3rd deadline serves no urgent purpose, and resetting both to dates, the court selects is the orderly path. Ex parte relief is appropriate. Ex parte relief is the proper vehicle. On July 3rd and July 15, 2026 dates, the July 3rd and July 15, 2026 dates are imminent, and a regularly noticed motion cannot be heard before them. The need to reset arose through no party's fault from the recusal and random reassignment of these motions. Defense counsel conferred with the government, which takes no position on the relief requested. No party is prejudiced by setting a conference in a schedule the parties have already discussed. For the foregoing reasons, Mr. Henley respectfully requests that the court grant the application and set the proposed.
Yeah, if this goes the way that he wants it to go, he's going to be for sure making his way home. And it's going to be a lot of people who are going to have, okay, local, I'm going to make sure I stay on that. It's going to be a lot of people who are going to have to eat crow because it's a lot of flu-flammery going on in these YouTube streets. And niggas gonna have to answer for said flu-flammery.
Schedule dated June 29, 2026. So what they're saying is basically, you're the new referee, judge. You set this shit. There is no rush to adhere to the old ruling, to the old schedule date. This is your shit. And the feds, they don't really give a shit, man. Like they can say that, oh, we're not available on July 2nd, but July 9th, we can. Man, we'll see. And there's a thing, a dark cloud over people trying to get shit suppressed. So let's go with the obvious. Could Big U have said some wild shit? Absolutely. Could he have said some wild shit against somebody? Absolutely. Hell if I know. I don't know. But even if that's the case, was it legal? See, you could do a shit ton of wrong, and as long as the law says it's okay, it ain't wrong. We're trapped in a space where people have the ability to see certain shit, but if they were in that same position, they wouldn't want that. No first year, no goddamn college first year lawyer would tell you, hey, bro, we not going to suppress any damn thing. You attack the credibility, you attack the evidence. It is what it is. So for those saying, oh, he's snitching, he doing this and he doing that, I'm like this. I don't know. But what I do know is if it was you on the other side, you ain't finna sit up there and not listen to your lawyer. Every lawyer in America would say, nah, we gonna have to go through everything and see what the hell we can suppress, because you can take certain shit out of context. We seen text messages in prior motherfucking trials where somebody say, yeah, man, I need to do this shit right here. And then you find out, man, days prior, it was about something else. Does that exist in this case? Hell if I know. I don't know shit about this damn case. All
right, man, I'm gonna let y'all catch the rest of this on Sadie Nash's page. Y'all saying kick it though, chat. Y'all know what time it is, man. We're going to continue to kick it, man. We're going to continue to kick it. We're going to continue to kick it. Continue to rock out a little bit. We're going to continue to rock out a little bit. Now, oh, my bad, chat. Hold on. My fault. Let's jump back into this next piece of content.
Really distressed when I first heard that there was like any foul play that somebody would potentially do.
Carjack 100 here. If you need your transmission check, come on down to Carjacks. I'm your transmission expert.
I'm glad that you enjoyed that content. We heard the cries, we heard the complaints. Now we don't got no intro, but we do got an outro with the same information, man. Make sure that you are tapped in. Make sure you dropping comments. Make sure you dropping likes. Make sure you subscribing to everything we have going on here at TNN Trap News Network, because we will be giving away some more Chiliana once we hit that 40,000 membership, 40,000 subscriber, threshold. We're going to make sure that we give y'all some Chiliana, man. So make sure that y'all stay tapped in. Make sure y'all stay looking out. Make sure y'all stay right here at TNN Trap News Network. The news you can use, the knowledge you're not finna get in nobody's college. Hit a like, hit a comment, hit a good subscribe button for everything we got going on here at TNN Trap News Network. We're gonna keep you updated on what's going on these YouTube streets. You already know the deal, man. If you enjoyed this content, throw the red dot to the left. You know the rest. We gone.
Hi, I'm Whack 100. When I'm not snitching on the internet, I'm snitching in real life for your own personal home security. Call 1-800-WACK-ATTACK. We're first, law enforcement second. Hey, I'm Adam22. Got an extra soul laying around? Be like Doughboy and Whack 100 and sell yours today. One soul equals a lot of clout.
Apollo Texas. It's dangerous. You can't come outside when it's dangerous. Work all in the floorboard. Tell the ops check the scoreboard. You can't come outside when it's dangerous. And if you shoot, you ain't miss. A nigga ball like game 6. A nigga ball like game 6.
You can't come outside when it's dangerous. Gotta get the blicky when it's dangerous. Young niggas, we done came from Nathan. Thought we would stop, we just can't quit. Thought we would stop, we just can't quit. Ballin' like us niggas up in game 6. Mix it with the bullshit, you can save it. Ballin' like us niggas up in game 6.
Game 60 bands on my neck when I got it on me. And I remember I was broke, I never let them hold me. Final seconds with my back against the wall. 81 points strong with this K, I call it Kobe. Running through this lettuce, nothing you can tell us.
gotta watch my back, I know that they get jealous. Real shit, I got rich, ain't gotta embellish. Real life made men, they call us good fellas. And I ain't got anxiety, I know it's intuition. May never love a bitch, but I for sure play my position. I know the streets talking, I'm cracking, so I ain't tripping. I said I play for keeps, but I guess them niggas ain't listening. Sick like Jordan, call it game 6. Shoot like Curry, and I can't miss. Nah, you can't come outside when it's dangerous. You niggas never outside when it's dangerous.
You can't come outside when it's dangerous. Gotta get the blicky when it's dangerous. Young niggas, we done came from Nathan. Thought we would stop, we just can't quit. Thought we would stop, we just can't quit. Ballin' like us niggas up in game 6. Miss it with the bullshit, you can save it. Ballin' like us niggas up in game 6.
I've been winning, tell my ops check the scoreboard. Money in the attic, work all in the floorboards. Late night, that's the life that we pray for. Overtime with the pack is what we in the game for. Put myself in the game and everything is just a memory. Just made a couple plays for the pain, not an enemy. Gotta watch my friends more, I gotta watch the enemies. Friends is hella fake, I know we're enemies' intentions. I let it go until it click if I'm aiming. Started staying safe and ended up staying dangerous. Game on the line, see the pressure I can take. Hall of Fame shit, so if it's mine, I'ma take. Niggas sick like Jordan, call it game 6. Niggas shoot like Curry and I can't miss. Niggas never outside when it's dangerous. Niggas never outside when it's dangerous.
You can't come outside when it's dangerous. Gotta get the blicky when it's dangerous. Young niggas, we done came from Nathan. Thought we would stop, we just can't quit. Thought we would stop, we just can't quit. Ballin' like us niggas up in game 6. Miss it with the bullshit, you can save it. Ballin' like us niggas up in game 6. You can't come outside when it's dangerous. Gotta get the blicky when it's dangerous. Young niggas, we done came from Nathan. Thought we would stop, we just can't quit. Thought we would stop, we just can't quit. Ballin' like us niggas up in game 6. Miss it with the bullshit, you can save it. Ballin' like us niggas up in game 6.
Sick like Jordan, call it game 6. Shoot like Curry and I can't miss. You niggas never outside when it's dangerous. You niggas always inside when it's dangerous. Shoot like Curry and I can't miss. Niggas sick like Jordan, call it game 6. Niggas never outside when it's dangerous. You niggas never outside when it's dangerous.